I am an advocate by profession. Well, this is something that is usually quite common, particularly in rural setups, where you will find that somebody comes and claims that the land that you are currently in possession of, they claim an interest in it. And usually you will find that they equally claim to have a title deed similar to what you also have. So now these are instances that have become quite common in the recent past, particularly post 2012, when there was a directive from the president that there should be registration of digital registration of titles or ownerships to land, leases, and all. So now, in the process of that transition from the manual registration to the digital registrations, there's been, I'd want to use the word foul play. There's been a number of foul play. I may not really indicate or specify from who, but there's been a lot of foul play that has resulted in various individuals procuring titles duplicate or similar to those ones that have been existent before. Yes, because ideally one piece of land that has one owner should have one title deed indicating that this is the person to whom this land is owned. Okay, so now when you have another person claiming interests, similar interests in that particular land, then already there is a problem. Okay, one has to be the correct title deed and another one has to be the wrong one. Okay, so already there is a conflict there. It is possible, but it is not legal because you may not really control. For instance, you have your land, you have your ownership documents, and then another individual comes, probably wants to sell that land, saying that he or she has title deed and he has the rights or ownership rights or ownership interest to that particular property, and as such they are able to transfer it to any other person who may want to purchase it. Okay, so when we have that conflict in terms of titles, then the step here would be to identify which is the correct one. Okay, which is the correct one, just to interrogate and find out which one was procured in the right way. Because remember, before you even get ownership of land, there are various things that you have to do, from the registration to the transfers to the purchases, or whether it is you are inheriting. Equally, there has to be a process that has to be followed. So now if we look at these legal processes and identify that this individual A followed due process, then we have to look at individual B and ask how come you have a similar title deed. Okay, so ideally you will find that there are two instances through which a duplicate title deed can be procured. One, either through fraud. Okay, there are times when title deeds are procured through fraud in collusion by different parties. The second instance would be where the registry, okay, or the Commission of Lands, they are the ones who issued that particular duplicate title deed, but they issued it through an honest mistake. Okay, so now in both instances, whether it was through fraud or whether it was through an innocent mistake, it voids that title or it makes it illegitimate. So this person cannot claim ownership to that particular piece of land. So now when you come to court or when you come and complain and say, hey, I have my title deed and person B equally has a similar title deed, then on the face of it, both title deeds look legitimate. So the court has to interrogate and find out which one is the legitimate one. Now there are various principles in law. The principle here that ordinarily operates, it's called the first in time prevails, okay, where the title that was procured first, on the face of it, is perceived to be the legitimate one. And then the one that came in later, of course, is perceived not to be the legitimate one. So now beyond that, it is not enough to come to court and say, I have a title deed, okay? Because all of you appear to have a legitimate title deed. So the court has to interrogate, go to the root of the title and establish who procured his or hers through the correct procedures. Every individual in court, or just like any other case that concludes in court, if you feel that you were aggrieved by the decision, you are at liberty to proceed and appeal. But remember, an appeal, in as much as it's availed to everyone, you have to appeal on specific grounds that will help you argue out your case. Yeah. So if, for instance, a judge, after looking into the root of the title, establishing that this was the procedure that was followed, and has outlaid his reasons towards arriving at person A having the legitimate title, if you are going to appeal, then you would probably be going to the higher court or the appellate court, explaining that in arriving at that particular decision, the judge probably misdirected his mind and failed to factor in some of the issues that are important, that ought to have been factored in. So you'll probably just be looking at how the proceedings went. If at all you feel that there are some issues that ought to have been factored in by the judge and he or she failed to do that, you will be pointing them out. But ideally, once such a determination has been done or has been made, it renders the duplicate title as being illegal or illegitimate, and one title has to stand. Yes, there are usually such instances, but then again, you would have to be keen to ensure that, there are instances where somebody has that duplicate title, and if you go and peruse through the lands registry, you'd find their names, okay? How they got there is probably a story for another day. And you have somebody else, an older person or elderly person, who has a title deed that is charred, those ones that they have kept beneath their mattresses or beds for too long. They got it way back, say in the 80s. This other individual probably got his in 2013, okay? So if you peruse through it, if you go to the registry, they probably have their details captured in. This other individual, since in the 80s when they procured that particular title, there was no digital registration. Their details were registered manually. Now the problem with a manual document, somebody can tamper with it, okay? So it may have been that the document has been tampered with such that their names have been omitted from the register. There are cases we have handled where we had the police come with us to the registry to peruse the registry document, or it's called a green book, and you can actually clearly see from the pages that some have been torn. Yeah, and in that particular case of ours, upon conclusion, it was determined that there was foul play from the registry. So I wouldn't really advise that these are cases that can comfortably be settled out of court, because you can agree and say, hey, I'm no longer interfering with your land. But what happens to the documentation or the various details that have been captured at the registry? So it's important to formalize it so that you avoid such cases recurring. Yeah, we could have, say, parents settle these things out of court. You've met your neighbor over a cup of porridge with the chief around and resolve this dispute. 20 years from now on, the parent is probably not alive, okay? He's left behind an 8-year-old child, okay? The neighbor whom they resolved that issue is still alive, okay? This child does not know this issue was resolved, okay? And then a similar dispute now resurfaces at that point where one party who was part of those out-of-court settlements is no longer existent, it now comes up again. So it would be important, as much as you may want to have those discussions and settle them out of court, it may be important to formalize them in the sense of having documentations, going to the registry so that you have full proof of this particular title. Yes, there are various ways through land can be transferred. Land can be transferred through a normal purchase and a subsequent transfer to the purchaser. Land can be transferred through inheritance, as you've pointed out, to the beneficiaries, and it also has its own type of process. There are instances where the government itself transfers ownership of land, where you hear that the president is in Mombasa issuing out title deeds. Okay, that is also another way through which land or ownership in land can be transferred. The fact that you have an order from court confirming or affirming that you are the legitimate owner, I would say you are as good as safe. Okay, but now it would be important, just as a matter of due diligence, to just go out of your own accord, go to the registry and try do a search of your property. Okay, there's something called a search where you pay for it. In the registry they do a search so that it establishes from their records who is the owner of this particular land. So if you do a search and it actually confirms from their records that you are the one, then that is as good as safe. You know, the funny thing is that as much as individuals are allowed to own land, quote unquote, the government owns all the land. Okay, so if today the government comes and establishes that we do have an interest in this particular land, the much you can do is dispute. Okay, there are various ways through which you can approach the court to dispute such a directive from the government. But remember, as long as the government can prove that its interest in this particular property or in this particular piece of land is pegged on public interest, you know, so it's going to be a matter of which one outweighs the other. Okay, public interests or private interests. Okay, so in the end you will find that public interest usually takes precedence over this, but then again you won't be left empty-handed. There are compensations that have to be given to you to compensate you for any disruptions that you may face if the government decides to come and probably take over your land or property.